Premarital agreements. What's our source of law? That's right, the UPAA, the Uniform Premarital Agreement Act. What do we need? Both parties have to have the capacity to contract, and you cannot pre-contract certain things such as child support. In some cases, you can pre-contract spousal support, but you can never pre-contract child support. Also, the requirements for a premarital agreement, they're enforceable when they are entered into 1, voluntarily and with fairness, and with 2, full disclosure of all material facts. And there's no evidence of fraud, duress, or unconscionability, meaning the bargaining process is lopsided or the result is so one-sided as to be unconscionable. The UPAA, courts will consider the timing of the agreement, the circumstances of the parties, including their age, their education, their business experience, sophistication, whether they had counsel, when and how it was presented. And the challenger, of course, has the burden of proof to prove it was not entered into voluntarily and with fairness, and not with full and fair disclosure of all material facts. Okay, marriage and annulment. Number 1, always lead off with marriage is a fundamental right. Marriage is an agreement with an offer and assent made by parties competent to contract. This is why minors cannot marry and why mentally ill people cannot marry. And it also is why drunk people cannot marry. There cannot be duress, undue influence, or, big surprise, no fraud going to the essentials of the marriage. Okay, so you have to be able to consent. So you have to be competent. You cannot be drunk like Britney Spears. You cannot be underage. And you can't have any fraud going to the essentials of the marriage. Can't have sex. Okay, so void ab initio, void from the get-go. Our marriage is void from its inception. It never existed. In other words, it's an illegal marriage, like a bigamous, polygamous marriage, or a marriage in which someone was forced into by some, foreign country's laws. And of course, a voidable marriage is usually due to minority, and the party entitled to raise the issue, in other words, the party who was the minor, has the right to raise that issue until a short time after reaching the age of 18. They have that window of opportunity. Until then, the minors can void it at their option, or guess what, Britney Spears, your parents can void the marriage for you. Okay. Of course, we have substantive requirements. You can't be too closely related by consanguinity or affinity. And can 2 people get married if they're underage? Well, yes, they can, but they need parental consent. And of course, we need our procedural requirements. Those aren't so important. Substantial requirements with the license, the witnesses, the certificates. That might be okay. You might get into residency requirements prior to marriage. Common law marriage. 1, intent to be married in the present. 2, made by parties competent to contract. 3, followed by subsequent cohabitation as spouses. Those are our 3 points. Intent to be married in the present, made by parties competent to contract, and followed by cohabitation as spouses. And I almost forgot, holding oneself out as being married. So actually there's 4. The intent to be married and an agreement to be married in the present, made by parties competent to contract, followed by cohabitation as spouses, and subsequently holding oneself out as being married. Okay, remember the putative spouse doctrine. There is a presumption that the last marriage is invalid. And so a putative spouse who enters into a marriage in good faith, believing that the marriage is valid, may be entitled to certain remedies, even if their marriage is not legal. Remember, they're not going to get a legal divorce because they never had a legal marriage, but they may have rights to spousal support and marital property acquired during a good faith belief that they were in a valid marriage. All right, divorce. Remember, domicile is sufficient for divorce. The state has the power and the authority to dissolve a marriage if one person is domiciled in the state, fact of residence, intend to remain, and the other side has what? That's right, notice. So what do we need for money and property? Yes, of course, we need personal jurisdiction over the defendant. We have to satisfy the long arm of the state, satisfy due process, and of course, serve the defendant. But you can dissolve the marriage just based on one party's domicile in the state. And what are our grounds? Yes, no fault, irreconcilable differences. We may run into residency and separation requirements. Okay, post-marital agreements, marital settlement agreements. Can you ever get those modified retroactively? No. Marital settlement agreements, the MSA is not modifiable. You cannot go back and get the property or money that you contracted away. Child custody, what's our source of law? 1-2, UCCJEA and the PKPA, which prevents parental kidnapping and preempts state law. This is important. UCCJEA, don't forget to mention the PKPA, which is a federal law, preempts state law, and it prevents people from doing things like moving away with their kids without notice. Where do we litigate? That's right, the home state of the child, the place where the child lived for 6 months with a parent, or if the child has been removed from the home state, the child's home state is, and there's a parent left behind in the home state, then the UCCJEA applies the look-back provision so that that home state where the child previously resided is still state. No home state, significant connection with substantial evidence. Significant connection with substantial evidence. Do we need PJ for an initial child custody order? No, we do not need PJ for the initial order. No PJ. All we need is that the defendant has to have notice and opportunity to be heard. But for child custody alone, we don't need PJ, just like divorce. Divorce, divisible divorce, no PJ. Original child custody, no PJ. Matters of money and property, like spousal support, property division, and marital assets, need PJ. Okay, so how do we award child custody? That's right, the best interests of the child, the parents' wishes, the child's wishes, the interaction and interrelationship of the child with parents, siblings, and other persons, child's adjustment to homeschool and family, and the mental and physical health of all persons involved. How about child custody modification? Oh yes, continuing exclusive jurisdiction to the state that gave the original order. Continuing exclusive jurisdiction under the UCCJEA, that state that issued the initial order has continuing exclusive jurisdiction. Child support orders. What do we need? PJ. We are going to litigate, hopefully in the home state of the child, but for child support, we don't need the original. Essentially, we don't need the home state of the child. We file for child support wherever we can get PJ over the defendant. For child support, what are we always going to quote? That's right, UIFSA, meaning all states have must issue mandatory child support guidelines, and states must enforce other states' child support orders. Forget about the FFCOA, just talk UIFSA and full faith and credit. Child support, what is that? Money. What do we need? PJ. But we file wherever we can get PJ, and everybody now follows the income shares model. Okay, remember child support is tax neutral. You can't discharge it in bankruptcy. You can't pre-contract it. You can't take it as a deduction, et cetera, et cetera. But how can we modify it? Oh yes, continuing exclusive jurisdiction to the home state where the child support order was entered. That state has continuing exclusive jurisdiction. So dad moves to state B, mom files a child support order and modification order in state B. Guess what? That's not going to work because the original state has continuing exclusive jurisdiction. And UIFSA is our law. Modify child support, continuing exclusive jurisdiction to the state which originally ordered under, that's right, UIFSA. You can't modify child support retroactively, but only prospectively. And what's our standard? Remember, it's a high bar, very high bar. Under the Uniform Marriage and Divorce Act, there has to be a substantial change in circumstances, making the original order unconscionable. Unconscionable. So if one person gets a permanent disability, we might look to increasing that order or possibly extending time. However, we might not get an order increased to permanent where it was temporary in the first place, and that person could find gainful employment. Remember, enforcement, it's not just full faith and credit. We have Title 4D of the Social Security Act. Title 4D, we register our child support judgment. Social Security goes out and collects that child support by any legal means. Suspending your licenses, withholding your wages, garnishing your wages, denying your passports, seizing your awards. Don't forget the 4D agency, Title 4D. Social Security, you register the child support in that state is going to enforce it by any legal means up to and including contempt. Okay, spousal support. What do we need to demonstrate? Need. What's our source of law? Our source of law is going to be the UMDA. We have to have need, meaning one, spouse lacks sufficient money and property to provide for their reasonable needs and is unable to support themselves through employment, or is a custodian of a child who needs full-time care. What is need? One, lacks sufficient money or property to provide for reasonable needs and can't support themselves through employment, or is custodian of a child who needs full-time care. All right, so remember, it can be temporary or permanent. The standard for modification of child support is substantial change in circumstances, meaning the original order was unconscionable, creates an unreasonable and extreme hardship such that the person would become a public charge. So, person becomes totally disabled, that might be an unanticipated, unforeseeable change, but most changes are not. Okay, finally, property division. All states divide property equitably, fairly and equitably according to the contributions of each spouse. What's excluded? Anything you pre-contracted in your premarital agreement, anything acquired by gift or devise. Premarital agreement, gift or devise, that stuff is premarital property. So step one, we're going to look at property acquired before the marriage, pre-contracted in your premarital agreement, acquired by gift or acquired by devise. That stuff is separate property. Everything acquired after the marriage, marital property. And then if it's commingled, then we're going to look at the source of funds and whether someone actually spent money and labor in making that property, like a business or a home, more valuable. Okay, so then we will divide the property and debt. It's presumed 50-50 is equitable division unless there is some other factor, like one spouse is very old, is disabled, they have prior marriage and they have a spousal support obligation there. And also dissipation of marital assets is going to figure into that. So when we divide property, look for someone who has dissipated the marital estate. Any appreciation, we're going to divide that equally. And debt, marital debt is divided equally. Separate debt is the responsibility of the separate spouse. Okay, parentage. Establishment of parentage. The UPA, Uniform Parentage Act, adopted in all states. First, it gives us you give birth to the child is yours. Giving birth, your child presumed to be the child's legal mother. This has implications for, that's right, surrogacy contracts. Then there is the marital presumption, Michael H. versus Gerald D. A child born to the couple, a married couple, is presumed a child of the marriage. And then there are 3 ways a man can establish paternity. 1, paternity testing can rebuttably identify someone as the father. Voluntary acknowledgement of paternity at birth, which is the equivalent of a court order. There is a window of opportunity to undo this after the child's birth, but it may be executed. Remember, this is voluntary at any time before the child is age 18. This means voluntary. Both parties say, you are dad. Finally, there is the putative father registry. A man who believes he is a child's father must register with the state's putative father registry. And if he does it, he's entitled to notice. And if he's not, his parental rights may be terminated without notice.